My son called me a ghost. Not to my face, he never had the courage for that. But I heard him say it to his wife one evening when they thought I was asleep in the back bedroom of their house. "Dad's just a ghost now," he said, his voice low and certain, the way a man talks when he believes something completely. He wanders around, he forgets things, he doesn't understand half of what we tell him. He's just here, taking up space. His wife laughed softly. Not a cruel laugh, almost sympathetic. "Then we should handle things before it gets worse," she said. I lay there in the dark with my eyes open and my hands folded on my chest, and I thought, you have no idea who you're talking about. My name is Arthur Whitfield. I am 67 years old. For 31 years, I was a forensic accountant, the kind companies called when someone had stolen from them and they needed to prove it in court. Not suspected. Proved. The kind of proof that holds up under cross-examination, that survives appeal, that sends people to federal prison. I testified in front of juries 43 times in my career. I won 41 of those cases. They called me the ledger in the industry. Not because I was boring, because once I opened a set of books, every lie inside them was finished. My wife Eleanor knew what I did. She was proud of it. She used to joke that I was the only man in America who could make a spreadsheet terrifying. She died 4 years ago, pancreatic cancer, 11 months from diagnosis to the end. I held her hand through every treatment, every night in the hospital. Every morning she couldn't get out of bed. When she passed, something in me went very quiet. Not broken, quiet. Monsieur Daniel is 41. He married a woman named Sandra 10 years ago. She is smart, ambitious, and has wanted things her entire life that she believed she deserved simply by wanting them badly enough. In the early years, I tried to like her. I brought wine to dinners. I complimented the house. I babysat their daughter Lily on weekends without being asked. I did all the things a father-in-law does when he is trying to build something. What I didn't realize was that Sandra had never wanted something built. She wanted something transferred. The first sign came 14 months after Eleanor died. Daniel sat across from me at my kitchen table, the same table where I'd helped him with math, homework, where Eleanor had served Thanksgiving dinner for 22 years, and he slid a folder across the wood toward me. "We've been doing some research," he said, "about estate planning, about protecting assets before you know, before things get complicated." I looked at the folder. I didn't open it. "Complicated how?" I said. He shifted in his seat. "Dad, you've been forgetting things. Last month you left the stove on twice. You missed Lily's recital, and you'd said you were coming. We're just worried about you. We want to make sure that when the time comes, everything is in order." I had left the stove on once, not twice. And I had missed Lily's recital because Daniel had given me the wrong date, something I knew because I still had his text message saved on my phone, screenshot and all. I had started keeping records of small things like that about 7 months earlier, for no reason I could have explained at the time. "Call it professional instinct. What's in the folder?" I said. "Just some documents. A financial power of attorney. We'd handle your accounts, your investments, make sure bills get paid on time." "My bills are paid on time," I said. "Dad?" "Daniel." I kept my voice even. I spent 30 years tracking money that other people thought was hidden. I know what a power of attorney means, and I know what it's used for. He looked at the table, not at me. "Leave the folder," I said. "I'll read it tonight." He left it. He also left with a look on his face I recognized from juries, the look of a man recalculating. I read every page that night. Then I called my attorney, a woman named Patricia Holt I had worked with on 3 federal cases in the 90s. I had helped put her ex-husband's business partner in prison for wire fraud in 2004. She owed me nothing, but she liked me, and more importantly, she trusted my instincts. "Don't sign anything," she said when I finished explaining, "and start documenting." "Already started," I said. That was the beginning. What followed over the next 8 months was the kind of slow, patient gathering of information I had done professionally hundreds of times. The difference was that this time, the subject was my own son. I want to be clear about something. I did not want to believe what I was finding. Every time I pulled a thread and found another thread beneath it, I gave myself a day to sit with it, to look for the innocent explanation, to assume I was wrong. I was not a father looking for reasons to suspect his child. I was an analyst looking for the truth. Wherever it landed, the truth did not land anywhere good. Daniel and Sandra had opened a joint account 18 months earlier, shortly after Eleanor's death, that I had no knowledge of. Through a contact at my former firm, I was able to establish that several transfers had been made from an investment account I shared with Daniel as co-trustee, an account Eleanor and I had set up for Lily's college education. The transfers were small at first, $400, $800, then larger, $2,000, $3,000, always just beneath the threshold that would trigger automatic bank review. Someone who knew how that threshold worked had structured those transfers. I sat with that fact for 3 days before I accepted what it meant. There was more. Sandra had told her sister I knew this because the sister had told her neighbor, who happened to be the husband of a woman in my Thursday morning walking group, and small towns are small, that Arthur won't be a problem much longer. She had said it in the context of the house. My house. The one Eleanor and I had bought in 1987, the one I had finished paying for in 2009, the one worth, by current estimate, just over $900,000. I also found, through Patricia, that Daniel had quietly consulted with an elder law attorney about the process for having a parent declared mentally incompetent. He had done this 4 months before he brought the folder to my kitchen table. I am going to tell you what I felt when I confirmed that, because I think it matters. I did not feel rage. I did not cry. I sat in Eleanor's chair by the window, the one she used to read in, and I watched the light move across the yard for a long time. I felt something settle inside me, the way a very old building settles after an earthquake. Still standing. Realigned. Then I made a list. The list was 14 items long. Over the following 3 months, I worked through every item on it, methodically, without telling anyone except Patricia. I gathered bank records. I obtained surveillance footage from my own property. I had installed cameras the previous year, ostensibly for home security, which no one had questioned. I had every financial document in my possession reviewed by 2 independent CPAs. I consulted with a forensic technology specialist about the digital trail of the account transfers. And I contacted the bank directly. I had a conversation with the branch manager, a man who had known Eleanor, who had attended her funeral, and I laid out, calmly and completely, what I believed had occurred. He listened. He made some calls. He froze the joint account. Daniel didn't notice for 6 days. When he did, he called me. "Dad, something's wrong with the account. The one we set up for Lily." "I know," I said. A pause. "What do you mean you know?" "I mean, I'm aware of the situation," I said. "I've been aware of it for some time." Another pause. Longer. I could hear him breathing. "Dad, we should talk." "We will," I said. "I'll let you know when." I hung up. I sat there for a moment. Then I stood up, put on my coat, and went for a walk. The air was cold and clean, and the neighborhood was quiet. I passed the park where Daniel had learned to ride a bicycle. I passed the church where Eleanor and I were married. I walked for 2 hours. When I came home, there was a message on my answering machine. It was Sandra. Her voice was very controlled, very careful. She said she was concerned about me. She said Daniel had been trying to reach me. She said they wanted to sit down together as a family, that there had been a misunderstanding, that she hoped I wasn't upset. I saved the message. I had been saving everything. 3 weeks later, Daniel filed a petition to have me evaluated for cognitive impairment. He cited the stove incident, still claiming 2, still wrong, and 2 doctor's appointments I had supposedly missed. I had not missed them. I had records of both appointments. His attorney submitted a declaration from a psychiatrist I had never met, who stated, based on a review of secondhand reports, that I might benefit from a formal evaluation. I want you to understand the precision of what they were doing. This was not a sudden grab. This was careful, constructed, layered. Someone had coached them. The timing, the documentation, the psychiatric angle. It was designed to look like concern. It was designed to look like love. I called Patricia the morning the petition arrived. "They filed," I said. "I know," she said. "I've been waiting. Are you ready?" "Yes," I said. "Arthur," she paused. "These things can get ugly." "Patricia," I said. I have spent 31 years making ugly things legible in a courtroom. I'm not concerned about ugly. She was quiet for a moment. Then she said, "Okay, let's go to work." The hearing was set for a Tuesday in March. It was to be held in the Harmon County Courthouse, the same courthouse where I had testified 11 times over the course of my career. I knew the building. I knew its rhythms. I had walked its hallways enough that the security guards had known my face. Daniel and Sandra arrived early. I know because Patricia's paralegal was watching the parking lot. They came in a new car, the lease on which, I had established, had been partially funded by money from Lily's account. They were dressed carefully. Sandra wore something that read, visually, as concerned daughter-in-law, muted color, no jewelry, a look of practiced worry. Daniel wore a suit I did not recognize, which meant it was recent, which meant it had been purchased for this. I arrived 11 minutes before the hearing began. I walked through the main entrance, through the metal detector, down the corridor to courtroom C. I pushed open the door. Daniel saw me first. He was seated at the petitioner's table with his attorney, a man I did not know. The moment I walked in, Daniel looked at me and he smiled. Not a warm smile, a confident one, the smile of a man who believes the outcome is already decided. He leaned over to Sandra and said something quietly, and she pressed her lips together to suppress her own smile. I walked to the respondent's table. I set down my briefcase. I sat down next to Patricia. I did not look at my son. What I did not know, what Daniel and Sandra could not have known, was who was going to walk through the door at the judge's bench that morning. The bailiff called the room to order. The judge entered. His name was the Honorable Warren Gable. He had been appointed to the Harmon County bench 9 years earlier. Before that, he had been a partner at a litigation firm in Cincinnati. And before that, 30 years ago, when he was a second-year associate at his first firm, and I was a 38-year-old forensic accountant who had just testified in a case that cleared his client of embezzlement charges that would have ended his career. He had shaken my hand in the hallway of a different courthouse and said, "Mr. Whitfield, you just saved my client's life. I won't forget this." I had not spoken to Warren Gable in over 2 decades. I had not reached out to him about this case. I had not even known he was the assigned judge until Patricia called me the Thursday before the hearing. "Do you know a Judge Gable?" she had asked. "I do," I said. "Well," she said, "he's going to know you." Judge Gable walked to the bench. He set down his papers. He looked out at the room, at the petitioner's table, at the respondent's table, and his eyes landed on me. He stopped. It was only for a second, a fraction of a second. But in a courtroom, where every gesture is watched, where stillness means something, it was enough. He looked at me the way a man looks at something he has to recalibrate around. He looked at me the way I had seen witnesses look at evidence they hadn't expected to be real. Then he composed himself and sat down. Daniel's attorney opened. He presented the narrative they had built: the stove, the missed appointments, the general decline, the concern. He was polished. He hit his marks. He used words like best interests and quality of life and loving family at regular intervals. Sandra nodded at appropriate moments. Daniel kept his expression set to worried. It was a good performance. In a different case, against a different man, it might have worked. Patricia stood up. She began with the stove. She submitted my phone records demonstrating that the supposed second incident had never been reported to anyone. No call to Daniel, no text, no mention in any message, because it had not happened. She submitted the screenshot of Daniel's text message with the wrong date for Lily's recital. She moved to the medical appointments. She submitted signed documentation from both physicians confirming that I had attended both appointments on the dates in question. She submitted the bank records. She submitted the transfer history, every amount, every date, every account number. She submitted the analysis from the 2 CPAs. She submitted the digital trail from the forensic technology specialist, which traced the authorization pathway for each transfer. She submitted the recording. I should explain the recording. 4 months earlier, Daniel and Sandra had come to my house for dinner, one of the regular dinners we still had, which I continued attending because stopping them would have changed the dynamic I needed to maintain. During that dinner, in my kitchen, Daniel had said something I needed preserved. He had said, while Sandra nodded, Dad, we just need you to trust us with the financial side. You're not equipped for it anymore. You know that, right? I had agreed, mildly. I had said I would think about it. I had said very little. What I had done was set my phone to record on the counter behind the fruit bowl 40 minutes before they arrived. Patricia played the recording in court. The room was extremely quiet. Judge Gable looked at the petitioner's table. Daniel's attorney asked for a recess. The judge denied it. The hearing lasted 4 hours. At the end of it, Judge Gable dismissed the petition. He did not simply dismiss it, he used the word baseless in his ruling, which is a specific word with specific implications. He ordered an investigation into the account transfers. He referred the matter to the county DA's office for review of potential elder financial abuse charges. He looked at Daniel directly when he said that last part. Daniel had gone pale about 90 minutes into Patricia's presentation and had not recovered. Sandra was looking at the table. Their attorney was writing something rapidly on a legal pad and not making eye contact with either of them. Judge Gable called a brief recess before moving to the next case. As the room began to move, he stepped down from the bench, which judges do not typically do between cases. He walked to the respondent's table. Patricia stood. I stood. He shook my hand. "Arthur Whitfield," he said quietly. There was something in his voice. I recognized the tone of a man re-seeing something he thought he understood. "The ledger." "Warren," I said. He looked at me for a moment. "I'm sorry this happened to you." "Don't be," I said. "It happened exactly the way it needed to." He nodded slowly. Then he went back to the bench. Outside in the hallway, Daniel was standing near the window at the end of the corridor. Sandra was not with him. His attorney had disappeared, probably to make calls. He looked like a man who had believed he was standing on solid ground and had discovered, all at once, that he had been standing on paper. He saw me come out of the courtroom. He didn't move. I walked toward him. I stopped about 6 feet away. He opened his mouth, closed it. Then, "Dad, Daniel," I said. I kept my voice very quiet, not angry. I want to be clear about that. There was no anger in me at that moment. There was something more tired than anger and more honest than anger. I know you needed money. I know the business hasn't been what you hoped and the house is underwater and things have been harder than you've let on. I know that. I've known it for over a year. He stared at me. "What I don't know," I said, "is when you decided that the way to solve your problem was to take what your mother and I built and to do it by making people believe I was losing my mind." I paused. "Your daughter's college fund, Daniel." He looked at the floor. "Lily is 7 years old," I said. He didn't say anything for a long moment. When he looked up, his eyes were wet. I don't know if that was real. I used to be able to tell with my son. I'm not sure anymore. "I didn't think it would go this far," he said. "Sandra thought." "I know what Sandra thought," I said. "I know who structured the transfers, and I know who contacted the elder law attorney, and I know whose idea it was to find a psychiatrist willing to write that declaration." I said it gently. "Not as a weapon, as a fact. The DA's office is going to want to talk to both of you. Patricia will reach out to your attorney with what we've compiled. I'd suggest you cooperate fully." He looked at me with an expression I hadn't seen on his face since he was a teenager. Lost, undefended, stripped of the story he'd been telling himself. "What happens now?" he said. "That depends on choices you make in the next several weeks," I said. "It doesn't depend on me. I've done what I needed to do." I picked up my briefcase. I started to walk away. Then I stopped, because there was one more thing, and I wanted to say it plainly. "Your daughter is going to have her college fund," I said. "I've already made arrangements with the bank. Whatever happens to you and Sandra, Lily is protected." I paused. "Because that's what you do for people who can't protect themselves. I would have thought you knew that." I left him standing in the hallway. In the weeks that followed, the DA's office opened a formal investigation. Sandra hired a separate attorney. Daniel, to his credit or perhaps just his better judgment, cooperated with the investigators from the start. Sandra did not. Initially, that turned out not to work in her favor. I moved back to my own house. I changed the locks, not out of anger, but out of practicality. I had dinner with Patricia twice, once to close out the legal business, and once simply because we are old colleagues who have been through things together, and sometimes that is reason enough. I called Lily on her birthday and sent a card with a drawing of a dog on the front because she had mentioned once that she wanted a dog, and I thought she deserved to be remembered about that. There were people in my Thursday walking group who found out what had happened, small towns, as I said, and some of them were outraged on my behalf, in that warm, combustible way that people get outraged about other people's situations. I appreciated the feeling behind it. I told them, honestly, that I wasn't outraged. Outrage requires surprise, and I had not been surprised. What I had been was methodical and prepared. And this is the part I think people miss when they hear a story like this patient with myself about what I was losing even as I was working to stop it. Because I was losing something. I was losing the version of my son that I had wanted him to be. The one I had told myself was still in there somewhere underneath the decisions he was making. That loss was real and I didn't argue with it. I let it be what it was. Eleanor used to say that the hardest accounts to reconcile are the ones where the loss is real on both sides. She was talking about clients. She was always accidentally talking about more than clients. I reconciled it. I put it in the ledger, under the correct column, and I closed the book. 6 months after the hearing, I sold my house and bought a smaller one 40 minutes outside of the city, near a lake I had always liked. The house has a good porch and a decent wood stove, and a view of the water in the mornings that I find I cannot get tired of. I have breakfast by myself most days. Sometimes I read, sometimes I just sit. I am not lonely. I have learned over the past few years to be careful about confusing solitude with loneliness. They are not the same thing. Solitude is what you choose. Loneliness is what happens to you. I chose this. Lily came to stay with me for a week last summer. Daniel arranged it, and it was one of the first things he did that I recognized as an attempt at something real rather than something strategic. She is 8 now. She asked me 3 times if I had a dog. I told her not yet. She accepted this with the philosophical patience of a child who knows what not yet actually means from adults. On the last day of her visit, she sat next to me on the porch in the early evening and looked at the lake and said, without any particular preamble, "Daddy said you used to find out when people were lying." "Something like that," I said. "How did you know?" she asked. I thought about it. I thought about 31 years of documents and depositions, about numbers that didn't add up and stories that didn't hold their shape under pressure. I thought about Eleanor. I thought about a hallway in a courthouse and a young associate who had shaken my hand and said he wouldn't forget. "People tell the truth with what they do," I said, "not always with what they say." So I watched what they did. Lily considered this seriously. She is a serious child. I like that about her. "What if they do bad things?" she said. Then I wrote it down. I said, exactly as it happened. And I let it speak for itself. She nodded as though this were a satisfying answer, which I think it was. We watched the lake until the light went low and the water turned gold and then gray, and then she went inside to wash up for dinner. I stayed on the porch a little longer. The evening was quiet. The kind of quiet that isn't empty, the kind that's full of things that don't need to be said. I have been in enough courtrooms to know the difference between silence that hides something and silence that simply is. This was the latter. I sat there until it was dark, and then I went inside.